Many of you likely use it, but sometimes I think we default to Westlaw because it's, in our view, faster, but we need to think about what we're spending, particularly if we're doing what President Getzinger asked us to do, some pro bono work. So they've made it very user-friendly over here. There's search tips for you. They'll help you set up this search to find whatever it is you're looking for. All right. Now, the South Dakota has some, the administrative rules. I have really a love-hate relationship with this website. It's about the only way to find our administrative rules. And I don't know if some of you younger people don't remember it, but those great big books, and you'd have to flip through and try and figure out what it was. This one, you can search in the text. And so I'm interested in marital status, how South Dakota protects people on basis of marital status for discrimination. So I can insert that, and it will give me every place that marital status appears. If I instead, let me back up here, insert, let's say I want to know who has to report child abuse. I can put child abuse in, and then I want to know who the reporters are, because a client calls and said, I have a volunteer that saw what they believe is child abuse. Do we have to report it? Well, here's all the places that I'm going to see any kind of reporters. It tends to gather more than you want, but you can usually tell by looking through it pretty quickly if you've hit what it is you're after. But I will say this one drives me crazy, and I do spend quite a bit of time. Sometimes I know the rule is there, and I have trouble finding it. It's not as user-friendly as it could be. Statutes, we have Dakota Disc in our office, so I tend to use that. But once in a while, if that isn't working for some reason, I use this. And one I'm interested in is if you can be discriminated against for tobacco use. And yes, in fact, you can be. There's a claim you can't be terminated for off-duty use of tobacco under certain circumstances. So just a way to get some pretty helpful information pretty fast. All right, now in terms of not legal research, but things we need to do, we want to schedule depositions, and we have lawyers coming from various parts of the country. So this HipMunk site is kind of funky. You can put in, I want to go from Rapid City to Baltimore, and I'm going to tell it what days I want to go, and it will then pull up all the flights that go during that time period. So if the lawyer I'm going to go with or I'm going to meet is coming from Denver, we can both do this at the same time, and we can find out if we can arrive in Baltimore at essentially the same time, so that I'm not there a whole day early. So it does take a bit to load. I put on page 4 of the outline, I did put an example of, I had to go to Nashville, and it showed all the flights. It gives you a rough idea of what the cost is. So here you can see whether you're going through Chicago or Denver, whether it's United or Delta, and it gives you all the flights for that time period, which I find really helpful. But it's got a funky name, HipMunk, which I thought was quite clever. 2 minutes, all right. All right, now I want to move on to property values. Zillow used to be quite a bit more helpful than it is. And if you like to find out what someone you went to high school with, where they live, what their house looks like today, you can hop right on Zillow and do that. You just enter the complete address. Pennington County has a free one, and in Minnehaha County, you pay $25 for it. So for the owner, you just stick in the owner's name, and let's say we'll just use Stan Adelstein, one of our state senators, and it will pull up all the details about the house. It will pull up the, you can get a detail sheet. It'll tell you about the level of finish, when it was purchased. Really helpful information if you need it for family law matters, business matters, really helpful. The other one I put in my, we don't have time to go over it, but this, for public interest attorneys, you can have some free research done by law students, and there's some research already there. I gave some examples in my outline, and I would urge you to take a look at it if you need some research. And then many of you probably know about PIPL, PIPL. It's a great way to search for witnesses, jurors, long-lost boyfriends that you might want to know where they go. And there's an astounding amount of information, which is, of course, a little frightening for some of us. But I would, if you're going to do research about jurors or somebody on the other side of the case, it's a way to do it that, in my view, is ethical. It's all public information. This is my brother, and I'll give you an example of how much information you can get from it. He is a professor at Mississippi State, and if he turned up as a witness in your case, you might want to know more about him. This will pull up. It will show you every place he has lived as an adult. It will tell you, for example, that he has a patent, gives you his home address, shows you where he did his postdoctoral work, where he did his doctoral work, someone he worked with. If you want to find out about his, maybe you want to find out about a witness, who they're related to make sure you have the right one, you can search the ancestry. And this one pulls up, and it will show, it happens to be an obit of my older brother, and you can see all of our family members in there, and it gives you an idea of who he's related to. I mean, that's an astounding amount of information that we can find out about a witness in 1 or 2 clicks. So again, I'm not professing to know everything there is to know about this, but I find these really helpful in day-to-day practice. So thanks. Yep, I'm going to pull up Rob's for him.
Just a reminder, it is of great benefit to the CLE committee to have you fill out the evaluation forms following the end of our CLE presentations this morning. We really do look at these and value your input in terms of the next presentations that we want to make and how to best present those to you. Our next speaker is Pat Dugan. Pat is the administrator for the State Court Unified Judicial System. She's here to talk about the Odyssey electronic program and what that will mean to us over the course of the next coming years as that is finalized and implemented statewide.
No, I don't have anything to comment on. Okay. Good morning. For those of you who were here yesterday, this is not a repeat of what I said then. Those of you who weren't here, you missed a great presentation yesterday afternoon. When Judge Fifley asked me to do this early bird, I thought early bird meant we'd come in like a day early. I didn't know that the day started at dark 0:30 this morning. What I want to talk to you about is how we are implementing the Odyssey project in the court system for the trial courts. As I did mention yesterday, contrary to popular belief, we do not have e-filing yet in the trial courts. We do allow e-mailing of some documents to the court, and we're particularly encouraging it in the Supreme Court for appellate matters. But we are currently working on rules that will actually identify all the requirements for e-filing. A committee of the Supreme Court has been appointed to start working on those. That committee does include some lawyers, it includes some judges, it includes some paralegals, because we know who does the real work in a lot of your offices. And of course, it includes staff in my office. For what we are doing now, we are having the clerk scan in documents in cases that come in after the clerk's office goes on to the new case management system. And so what I want to talk to you about for just a few minutes is the rule that is in effect that addresses those documents and will affect you and your practice as your circuit or your county comes onto the Odyssey system. Supreme Court Rule 1201 was adopted by the Supreme Court on February 21st, and it was published in the Bar Newsletter in March. If you didn't look at it, you might want to go back and look at it. That rule does recognize electronic documents as the official court record. It defines an electronic document management system, which is what we're putting into place now. It defines the electronic record. It defines an electronic signature. So right now, the clerk has the responsibility for doing all of the scanning and putting the records into the case management system that we have going on. Of course, in the future, you will be scanning your own documents, or someone on your behalf will be scanning those documents and sending them to the court. And our role will shift slightly from doing the scanning to auditing those documents that come in, accepting them or rejecting them, processing payments, getting them into the rest of the system that will now eventually generate notices and calendar hearings and provide for all of that. A couple of things you do need to know about the documents that are now being scanned into the system. And for those of you who aren't aware, this affects any cases filed in the 3rd Judicial Circuit or the 5th Judicial Circuit. All of the counties in the 3rd and the 5th have now been converted over to the new system. In October, the 2nd Circuit will be going live, first week of October. Then in about February or March, we will be going online with the 1st and the 6th Judicial Circuits. And by this time next year, roughly June, more or less, give or take a week or two, the 7th and the 4th Circuits will be going online. But there are a couple of important things you need to know. So the case gets filed, the clerk scans the information in. We will be keeping the paper for those scanned in documents at this time for about 180 days. And after that, we're going to be getting rid of it. So if you file something now, and a month from now you want to see that original piece of paper, we've still got it. We will have it for about 180 days. That could be changing down to about 7 days. We're looking at exactly what our needs are for retaining the paper. Now, there are a couple of exceptions. Right now, those exceptions include wills that are retained for safekeeping. We're going to keep those in paper form. And any kind of ceremonial document, like an adoption record or a marriage certificate, oaths, some of those kinds of papers, we will be keeping in paper form, at least for the time being. What we have to figure out is how long do we keep everything? Why do we need to keep it? How is that going to tie into the records retention schedule that we follow? Do we keep papers or give them back to you? Do we make you come get them? Do we let you come get them? And what's going to happen with those? All of that is still yet to be determined. What we're doing right now is setting up the foundation of the whole system so that we can capture the data and the documents. That becomes the official court record. And then from there, we can build on the added features that you've all been saying you want, like e-filing, or e-payments, or for law enforcement, e-citations. For just about everybody, e-access. Access is something that will affect some of you now if the counties or circuits that you work in have already converted to the Odyssey project. We do not have public access terminals in the clerk's offices yet, but we're working on getting those in place or providing some other electronic access. One of the issues that we have is physical space to put a terminal in, the hours that it's available, who's going to troubleshoot it if there's a problem, who actually needs it and has priority, how long can you stand there and tie up the machine if there are other people in line wanting it. And so there are some details we have to work out. We are not currently scanning in small claims cases because if any of you have done small claims work, you will know that we do not actually generate that paperwork on a piece of paper. It's on a file folder. And so we're converting that over. But right now, small claims are not part of our scanning effort. We're also not scanning in oversized documents. They have to be standard 8.5 by 11 paper of good graphical quality at 300 dots per inch. That means nothing to me, and I guess it probably means not much to you, but it's important to the system, and therefore we're going to make a big deal out of it. We are not scanning in exhibits. Obviously, some can't be scanned in, but we're trying to figure out the best way to manage those processes as well. One thing that will affect some of you more than others, depending on how often you have come to the court to check out files, is that attorneys will be provided electronic copies in lieu of file removal if the documents are available electronically. So rather than let the paperwork go out of the courthouse now, we're going to be sending you electronic copies. As you know, this isn't free. One of the reasons it's taken us so long to get this far into the system is because of the cost of converting old programs that have been capturing data for 30 years. And there will be a cost for electronic transmission some way, somehow. There will be costs for copies, and we don't have all of the details worked out. If a clerk doesn't charge you right now, just don't look that gift horse in the face, because we're trying to make the system work, and we're making a lot of accommodation right now to get people comfortable with the idea that the paper is not going to be around forever. For those of you who are worried that we are going paperless, let me tell you that we are using the terminology paper on demand. We know that there are some people who just will not be able to accept a virtual file, and that includes judges. But what we're trying to do is to make this transition as painless as possible, knowing that some of us are going to get squeezed from time to time and feel the pinch. The other thing that may or may not affect you right now is that when we scan documents into the system, if you want copies of things and we have to send them to you, the largest document we will accept is 50 pages. If a document that you happen to submit to the trial court is more than 50 pages, we're going to break it into 50-page chunks. It may not mean anything to you, but we need you to know that we know what we're doing with our papers, and you have to trust that we're setting up the system that will allow us to not only capture the data, but be able to store it and retrieve it in a way that makes sense to us and eventually will allow you to access those documents or to file them from your own desk or comfort of your couch or wherever it is you choose to do that. There are a lot of details I could go over. Most of it is not very interesting as far as I'm concerned. But what is more interesting to you is who's going to do what when, and what kind of access are you going to have, and what's it going to cost you, and what's it going to mean for your clients. If you haven't noticed already, the UJS does have an information table set up out in the hallway, and I'll be there most of the day. Greg Satizan, who is my general legal counsel and director of policy services, is also going to be in and out today and available to answer some questions. We have written information for you. We have little maps that are colored that will show you when your county is going online. We also have a survey form out there we'd like you to fill out. If you don't fill it out, and even if you do, you're probably going to get one by email next week. If you've already filled out the paper form, you don't need to complete the email survey. But what we want to know as we're developing these rules is what kind of access do you want? How would you prefer to get to documents? What fees are you willing to pay? And let me tell you, there is going to be a fee some way, somehow. But we need to know what the comfort level is, what the expectations are, so that we can build those rules around that system. Now, for some of you, you're looking pretty wide awake, and I'm still not that awake, and so I am going to finish this up and go back out to my table where I can take your questions one-on-one unless there is some burning issue you think everybody in here needs to know the answer to, I would be willing to take a question right now. All right, thanks.
Thank you. Benjamin Franklin once said, "Early to bed, early to rise makes a man healthy, wealthy, and wise." As you can see from the presentations that we have this morning, we're obviously making you wiser. Hopefully, the presentations will help make you wealthier. I took a look at the breakfast table. There is absolutely no doubt we will not make you healthier. Our next speaker this morning is Rob Anderson. Rob is with the Mayadam firm in Pierce, South Dakota, is a very experienced trial practitioner, is a resource that I went to when I was in practice for questions regarding bad house cases, because Rob has significant experience in that area. And I've asked him to come speak to you today about the bad house case. Rob?
Thanks, Judge. I have had no end of people who've talked to me prior to today saying, "Why are you talking about bad house cases? There's not a lawyer in the world dumb enough to take a bad house case anymore." Well, that's not entirely true, although I know there are lawyers and law firms that have policies against getting involved in these kind of cases for a variety of reasons, primarily because at the end of many of them, you have an unhappy client, a lot of costs, and no way to pay them. That's not true with all these cases, but it's very common. So you need to be very selective in terms of what you do if you want to get into the bad house case business. And that applies not only for plaintiff's lawyers, but defense lawyers as well. So a bad house case, what is it? I don't think it's that, because you've made your own problems if you have a house like that. Now, you've got to bear with me because, as Jane said, I am not a genius when it comes to using technology. Is a bad house case that? Well, you might be getting closer to a bad house case with something like that. Now, and this is important because you have to be able to recognize these things. Oh, no, did I goof? There we go. Now, Judge Fifley said I had a lot of experience with bad house cases. There's a lot of bad houses in that picture, and one of them, unfortunately, in the lower part where the 8-foot fence is covered with water, is my house. So that's a bad house. That's not a bad house case either. Bad house cases are cases where you need to have a couple things present. And one of them is you have to have a bad house with a potential remedy against some third party who's responsible for making it into a bad house. If you don't have a remedy and don't have a party, you don't have much of a case. So that's the very first step in analyzing any bad house case, is to determine whether it's a real case, whether you can take it. So for the purpose of this discussion, a bad house case is 1, residential, not commercial or industrial. 2, involving a defect of some type which either develops in the house after you purchase it or acquire it, or which pre-existed your purchase and which you were not aware of if you're the buyer. And 3rd, and most importantly, you have to have at least a potential remedy against some third party who has some ability to pay. I'll talk more about that as we go along, and I don't want to sound too much like a plaintiff's lawyer, which I'm not, but there's no use getting involved in a bad house case if you have no ability to pay for damages at the end of the day, because these can be painful. I've had a lot of lawyers tell me, and I can speak from some experience, that bad house cases can be as unpleasant as divorces. And this comes from dealing with your own client primarily. They can be difficult. They're emotional for many of the same reasons on both sides. And if at the end of the day you fight and claw and either try the case or settle it or get to the point where you can't settle it because there's no money, you've got to have some solution that's going to keep you happy and your client happy, and that can be very difficult. I've categorized bad house cases into 3 really generally broad categories. One are failure to disclose cases, and I think this is probably the most underutilized area from plaintiffs' perspectives in terms of bad house cases. Failure to disclose cases are cases that a seller may have a remedy pursuant to the South Dakota disclosure statutes. SDCL 43-4-40 creates the remedy, or creates the obligation to complete the disclosure. I think it's underutilized, and it has a lot of advantages for both sides, actually. It's a better case to be in if you're a defendant, and it's certainly a better case in some ways to be in if you're a plaintiff. Second, and this is the broadest subset of the universe of bad house cases, and almost everything falls within this scope, and that is defects in construction in general. These defects can be in new construction, repairs, remodeling. They can involve design, soils work, excavation, soils testing. They can involve just about anything, and these almost everything falls within this really large subset. And then the third subset of the bad house cases, which you see a lot from the River West and not quite so much in the eastern part of the state, are the cases involving expansive soils which create problems with construction. I'm going to talk about those more in detail later, but they are, that subset of expansive soils cases creates many of the cases you see in category 1 and 2 and kind of presents some special and unique problems just because of that. Let's talk a little bit about the disclosure cases. SDCL 43-438 creates a duty on the part of the seller of residential property only to furnish a completed disclosure statement. These disclosure statements have changed